Hello, dear friends. In the fifth lecture on Erasmus Ecclesiastical Law, we speak about, and we continue to speak about, the system of state church or system of institutional unity. Finland, Sweden, and the United Kingdom offer legislative guarantees of relative ecclesiastical autonomy for their state churches. That is a limited autonomy for their churches. And Greece also. While Denmark offers a limited self-administration for its state church. Denmark is the only state with a state church system in which the state church, that is the Evangelical Lutheran Church of Denmark, has not a general synod that is a supreme body for the state church, while all the other churches, all the other state churches in Europe have supreme ecclesiastical bodies, that is general synods. The Evangelical Lutheran Church in Finland, the Anglican Church in the United Kingdom, the Evangelical Lutheran Church of Iceland, the Evangelical Lutheran Church of Sweden, which now is not a state church, but it retains its property as its former property as a national church. It is a national church, but not a state church, as it was until 2000. And in 2000, Evangelical Lutheran Church in Sweden was a national and a state church. That is the meaning of the national church until 2000 was that of a state church, but not from 2000. In Greece, there are two state churches. The Orthodox Church of Greece and the Orthodox Church of Crete are state churches. What is the difference between a state and a free church? The difference is that the state churches have statutes enacted by the respective parliaments, while the free churches enact their statutes through their legislative bodies. If if a church legislates its statutes, then this church is a free one. If not, it is a state church. In some countries, the state churches can be organized as public law corporations, and in others, private law corporations. On the other hand, non-state churches are organized as private law corporations. Now I pass to the systems of institutional separation. The systems of institutional separation can be subdivided into three subsystems. First subsystem, subsystems of Catholic established church. Second subsystem, subsystems of special recognition of one or more creeds which may disguise an established church or churches. Third subsystem, subsystems of a multi-denominational state. All these three subsystems can be considered as belonging to the separation without a talaik. The separation of a talaik is found only in France from historical reasons. Subsystems of Catholic established church. Subsystems of Catholic established church prevail in Liechtenstein, Monaco, and Malta. The principal effect of these subsystems of Catholic established church is that the Catholic Church is considered as an established church, but it does not acquire the status of a state church, because from the ancient years, very ancient years, from the beginning of the Christianity, Roman patriarchates, the now Holy See, does not accept for the Catholic Church to become a state church in any country, because Holy See wants to preserve the full extent of the right to autonomy for the Catholic Church in each country in which the Catholic Church is found and acts. The Constitution of Malta makes Roman Catholic values an evaluative basis for its legal order. The subsystems of special recognition. subsystems of special recognition under the influence of Orthodox culture, that is, of the Oriental Roman Empire, that has sufficiently assimilated human rights principles, may enshrine the basis for exclusive privileged treatment of an established church or churches. Special recognition of one or more creeds is accomplished by the Constitution, by law, or in practice. Special recognition of one or more creeds is accomplished by constitution in Bulgaria, Fyrom, and Moldova. By law is made in Russia. In practice, as a result of government policy in Belarus and Romania. However, the principle of equality of religious organizations, of separation of state and creeds, and of autonomy of religious organizations are constitutionally safeguarded expressly. The principles of equality of religious organizations is constitutionally safeguarded in Belarus, Russia, and Fyrom. The principle of separation of state and creeds is constitutionally safeguarded in Bulgaria, Russia, and Fyrom. And the principle of autonomy of religious organizations is constitutionally safeguarded in Fyrom and Moldova. Furthermore, the Russian constitution guarantees the secular character of the state and the non-establishment of religion. The Moldavian constitution also enshrines the principles of state cooperation with recognized creeds and the potential regulation of their relations through conventions. Bulgaria, Fyrom, Russia, and Moldova recognize their Orthodox churches. At a secondary level, Russia recognizes its other traditional religions, namely other Christian sects, Islam, Buddhism, and Judaism. Moldova, by virtue of its law, continued to attach the recognition of creeds to registration with the government. Russia, despite its constitutional system of positive secularity, that is, the system of État laïque, has enacted a law that seems to discriminate in favor of traditional creeds, particularly the Russian Orthodox Church, through unequal treatment of religious associations and onerous preconditions for their registration. Belarus has implemented a policy favoring the Russian Orthodox Church. Registration of religious organizations with the government is mandatory in Belarus for public manifestation of religion, and this is contrary to the international human rights standards Successive Bulgarian governments have intervened in the internal affairs of the Orthodox Church and the Muslim community without respecting their autonomy. The case is Hassan Chaoush, and spiritual council of Muslim community against Bulgaria are well known. Moldova recognizes and registers not only the Orthodox Church of Moldova, subject to the Russian Orthodox Church, but now, and also the Bessarabian Orthodox Church, subject to the Orthodox Church of Romania, and the Church of the true Orthodox Moldova, subject to the Russian Overseas Orthodox Church. The cases of the European Court of Human Rights, Bessarabian Orthodox Church, and True Orthodox Church of Moldova against Moldova are well known. In the past, Moldova did not recognize these later two churches, that is, Bessarabian Orthodox Church and True Orthodox Church of Moldova, because it considered them to be schismatic in relation to the former one, that is, the Orthodox Church of Moldova of the Moscow Patriarchate. According to the cases, Bessarabian Orthodox Church and True Orthodox Church of Moldova, Moldova should recognize them as religious communities in the context of a democratic religious pluralism. I have to note some things. As it concerns the divergent religious communities, they enjoy religious freedom and equality. The divergent religious communities are considered as separate religious communities from the mainstream one. If we take into account the Orthodox Church of Moldova of the Moscow Patriarchate, which is the canonical church in Moldova, because Moldova constitutes a territory of the Moscow Patriarchate recognized by the community, the Commonwealth, the Confederation of all the Orthodox autocephal churches. The true Orthodox Church of Moldova is a schismatic one from the canonical point of view, that is, from the internal law of Orthodox Church, in comparison with the Orthodox Church of Moldova, of the Moscow Patriarchate. But as it concerns the law, the state law, is not interested in the heretic or schismatic nature of a religious community. For the state law, there are not heretics, there are not schismatics. There are only churches or religious communities. And the heretics or schismatics are divergent religious communities. And the divergent religious communities enjoy religious liberty and religious equality. They are separate churches or religious communities. So the True Orthodox Church of Moldova is a separate church and has the right to be recognized by the state, as in Greece. The old calendarists are divergent in comparison with the official Orthodox Church of Greece or of Crete, in general of the Orthodox Church, official Orthodox Church in Greece. And because the old calendarists are divergent, they have the right to constitute a separate church and to be registered and to be recognized by the state. But as it concerns the Bessarabian Orthodox Church, I have some different observations. The Bessarabian Orthodox Church, which has as a territory Moldavia, is not a divergent church. It is an autonomous church from the canonical point of view, that is, from the point of view of the internal law of the Orthodox Church. It's an autonomous church belonging to the Patriarchate of Romania, Orthodox Patriarchate of Romania. But the Orthodox Patriarchate of Romania does not have any jurisdiction on Moldova. Because the canonical Orthodox Church acting in Moldova is only the Moscow Patriarchate. But now, on the territory of Moldova, there are through canonical Orthodox Patriarchate, and this is consistent, this is inconsistent with the internal law of the Orthodox Church. because it is clear that the territory of Moldova is an ecclesiastical territory belonging only to the Moscow Patriarchate. So, the case Bessarabian Orthodox Church against Moldova of the European Court of Human Rights is not a successful one because it wrongly considered Bessarabian Orthodox Church as a divergent church. Bessarabian Orthodox Church is not a divergent church entitled to enjoy religious liberty and equality. The European Court of Human Rights should take into account, and it has not acted so in the concrete case. It should have taken into account that according to the internal law of the Orthodox Church, to which Romanian Patriarchate and Moscow Patriarchate belong, the territory of Moldova is an ecclesiastical territory of Moscow Patriarchate. And the Church of Bessarabia, belonging to the Romanian Patriarchate, did not have the right to be established and function on the territory of Moldova because in each ecclesiastical territory only one autocephal patriarchate should have jurisdiction. So correctly, the Moldovan government rejected the application of the Bessarabian Orthodox Church to be recognized and to be registered. Because, as I have said already, Bessarabian Orthodox Church of the Romanian Patriarchate is a canonical church. It is not a dividend church. So, Bessarabian Orthodox Church is not a separate church. There is the recognition and registration of the Orthodox Church of the canonical Orthodox Church of Moldova belonging to the Moscow Patriarchate, and there cannot be any other Orthodox Church non-divergent which has the right to be recognized and to be registered according to the state law of Moldova. For those reasons, the case Bessarabian Orthodox Church against Moldova was not a successful one because the Moldovan government did not violate the religious manifestation in association with the religious association of the Orthodox Church, as it did, as it concerns the divergent, that is, the schismatic from the canonical point of view, true Orthodox Church of Moldova. Now we have finished our 5th lecture. Thank you for your attention.